Good morning, everybody. I'm going to get this webinar underway. The numbers are stabilizing slightly, although there's a few more coming in. Welcome to the Cornerstone Barristers Housing Team second webinar of this year. My name is Sarah Salmon and I'm joined today by Jack Barber. We are both members of the housing team here at Cornerstone. My understanding is this webinar is 45 minutes this morning, so we have a lot to get through in the time, so I'm going to make admin quite short. First of all, there is a question and answer button should be at the bottom of your screen. Any questions you do have, please try and put them in there. We will try and get to them or answer them as best we can. Also, just a reminder to everyone today that Cornerstone's Housing Day will be on the 13th of October of this year. And there are a couple other webinars coming up as well. One in May, on the 21st of May, about social housing regulation and consumer standards, and also avoiding discrimination challenges in allocation schemes, which is on the 9th of June. You can find all of those details on our website. So just turning to what we are going to cover today, if we can go to the next slide, please, Jack. There are obviously a number of decisions under Part 7 of the Housing Act 1996 that can come under scrutiny either by way of appeals in the county court or judicial reviews in the High Court. Also, more recently, we've seen the Ombudsman looking at homelessness decisions, and decisions can come under scrutiny via the Ombudsman as well. But there's just far too much of that to cover in 45 minutes. So with that in mind, what we're focusing on today is the decision making. And there's quite a heavy focus on Section 184 of the Housing Act 1996, although we also cover Section 202 because this is about appeals. But the reason for that is, as we see it, is that a good Section 184 decision, where you have to consider most things that you'd be going on to consider on review anyway, builds the foundation for what will then be a strong review decision. And therefore, once you get to the appeal in the county court under Section 204 of the 1996 Act, you'll be a much better place to defend those appeals. So we'll be looking very briefly at the legal framework, some common issues that arise, a few practical tips, some other powers and duties that you have to think about along the way, some points on appeal once you get to appeal, and also we'll just look at some recent case law. These slides will be emailed to you after the webinar today. So there will be quite a canter through some of the sections, but you will be given the slides at the end. So I'm going to hand over to Jack now, who's going to cover legal framework.
Thanks, Sarah. So I'm going to quickly give you a whistle-stop tour of the legal framework, principally in relation to the Housing Act 1996. I don't want to necessarily teach grandmothers to suck eggs, but I think it's important that we look at the building blocks, the statutory building blocks. There's just a fire alarm going off in the background. It's a demo. Before we go on to the substantive matters. So in terms of the statutory framework, obviously Part 7 of the 1996 Act provides the principal statutory underpinning for action to prevent homelessness and provide assistance to people threatened with or actually homeless. The legislation has been amended over time with key amendments, including the Homelessness Act 2002, for example, which required strategic approaches, including homelessness prevention strategies. And also the Homelessness Reduction Act 2017, which basically front-loaded the duties to prevent homelessness earlier in the process. The Domestic Abuse Act 2021 also enhanced support for domestic violence victims, and we'll look at a little bit at those later on as well. But one of the key themes that always stands out when you look at the Part 7 of the 1996 Act is that the questions of who gets help and who gets what type of help often falls to the local or housing authority. And so it's up to them to provide an answer a lot of the time and to reach their own judgment on that. And so you'll see throughout the legislation, there's lots of references to, for example, the local housing authority is satisfied that. And that is an important thing to focus on in the context of an appeal, because obviously there is a degree of discretion afforded to decision makers. What on appeal the courts are often concerned about is the legality of that decision making and whether the decision fell within the margins of discretion that's afforded to them within the law. Obviously another key point is that local housing authorities must give proper consideration to all applications for homelessness assistance. And if there's a reason to believe that an applicant may be homeless or threatened with homelessness, the local housing authority must make inquiries in relation to whether it owes any duty. And so we're going to look at that provision in more detail later on today. It's also worth noting that when we go to section 1841 of the Housing Act 1996, you get this phrase, where the authority has reason to believe. In terms of the approach that they take here, what we're thinking in relation to the 1841 duty is we're concerned with once an application has been received. Obviously, that reason to believe, it's up to the local housing authority in terms of whether it has that reasonable belief. But the next stage in the application process is often for the authority to make inquiries into the application. Now, when there's a receipt of an application, that obviously leads to the question, well, what is an application? Now, there's no requirement for a specific form to be filled out in order for there to be an application. But really, what we're thinking about here is the local housing authority making sure that it properly inquires into that once it receives it. And so what we're thinking about in terms of the purpose of inquiries is to determine what, if any, substantive duty is owed. And obviously, there's a very low threshold for inquiries, and we've got a case there at the bottom which refers to that. So in terms of the nature of inquiries, Sarah is going to discuss this, but it's worth noting that it's for the authority and not the courts to determine how necessary inquiries are made, including who should conduct interviews and what questions should be asked. And obviously that's subject to a Wednesbury review in an appeal context. But again, it's worth focusing on the fact that it is left to the decision maker in terms of what are the appropriate and necessary inquiries in a particular given case. Sticking with 184 for the time being, one of the things that people need to be careful of when receiving an application, and this is in a view to preventing a successful appeal, is being aware of the potential joint application. And so in section 1831, there's a reference to a person, but that's referenced in the context of the person making the application. And the courts have indicated that applications made jointly should be treated carefully with clear consideration of the relationship between applicants and whether circumstances justify joint treatment. Now, in terms of how decision makers should approach that, it's worth treating a potential joint application with a degree of separation unless there's clear evidence to support joint consideration. And there's a series of authorities which we've listed here, but what the authorities emphasize is the need to evaluate individual needs independently of one another. Decision makers need to ensure that they carry out thorough and fair inquiries in relation to each individual in order to reduce the risk of challenge. And a failure to address individual needs and vulnerabilities could potentially render a decision unlawful, and that obviously could give rise to a potential ground of challenge later down the line. Now, another way that decision makers might start to cover themselves in relation to a potential joint application is the clear documentation of decision-making processes. Now, this applies more widely in the context of homelessness decision-making. Clear documentation of a decision-making process also enables a decision maker to reduce a challenge based on inadequate inquiries or unfair treatment. And so we'll just move on to this subsection 3 here. And that's set out at the top. But once a local housing authority is faced with an applicant threatened with homelessness, obviously the local housing authority must start to make appropriate inquiries. The duty to make those inquiries cannot be postponed until an applicant is actually homeless. The courts have said that, and there's no statutory requirement that inquiries must be carried out within a particular time. Now, that might sound slightly counterintuitive or cross-cutting against one another, those two statements. But in reality, what decision makers need to take away from that is that the duty can't be deferred. An authority, for example, can't avoid the inquiry duty on the basis that it will owe no duty to a person whose priority need has been lost by the time that the inquiries have been completed. That example is the example of Robinson and Hammersmith. But it's also worth thinking about the duty to make inquiries needs to be taken, can be taken in stages. And so there might be a succession of different decisions that are called on in the decision-making process, which will require further inquiries to be taken at a particular point in time. And so, for example, sometimes what that means is local housing authorities are often going to have to inform an applicant of a series of decisions rather than just one decision. So that might mean that they can be combined into one notification, or there might be a series of notifications. So, for example, there might be a first decision on eligibility. If someone's eligible, what decision is required, what duty is required, if any, whether someone's homelessness or threatened with homelessness, and a decision that no duty is owed. Those things all might be communicated. And then there may be also a notification of a decision that would bring an interim accommodation duty to an end. So you can see that it's a multifaceted decision-making process. In terms of the appeal process, now obviously Section 202 makes provision for a review of a particular 184 decision. And so an applicant may challenge the 184 decision by a review under 202 of the 1996 Act. What Section 188 does is to provide an authority with a power to provide accommodation pending review. That's obviously a discretionary power. And the procedure on review is set out in regulations which are prescribed and made pursuant to Section 203 of the 1996 Act. Now, in terms of those regulations, we haven't got time to rush through them all today, but it's worth noting that at 7.2 of the regulations, there's a provision that if the reviewer considers that there's a deficiency or irregularity in the original decision, but is minded nonetheless to make a decision which is against the interests of on one or more issue, then the reviewer must notify the applicant and that the reviewer is so minded and the reasons why, and that the applicant or someone acting on the applicant's behalf may make representations to the reviewer orally or in writing, or both orally and in writing. And so what that is a procedural safeguard which essentially allows an applicant to have their say on the point made above. And the courts have been very clear that these procedural safeguards contained in the regulations are really important, and that to depart from them could in itself give rise to a potential ground of challenge. And so it's worth decision makers bearing that in mind when taking decisions, that they need to make sure that those decisions are made as fairly as possible, having regard to the procedural safeguards which allow applicants to have a fair crack of the whip. There's a couple of points there which we've made in relation to the relevant principles on the procedure of review. There's points there about, in particular, where new facts emerge that relate to an important issue in the case, an authority must consider whether those new facts expose a deficiency in the original decision. What's emphasised in these regulatory provisions is essentially that need for decision makers to keep alert throughout the decision-making process to changes in position, which mean that their decision-making process might have been deficient at some point. And so, for example, where an applicant puts forward new information for the purposes of review, which was not before the original decision maker, a reviewer must serve a minded to find notice if that new information could plausibly make a difference to the review decision. Okay, so I think at this point, I'm just going to hand over to Sarah, I think. Is that right, Sarah?
That's right, yes.
Yeah.
I'm going to take you all through inquiries. In my mind, and particularly on review, it can be quite important. Inquiries is one of the most important things to get right, because if the right inquiries are made, it just cuts out quite an easy challenge for an applicant to say, well, I told them about X and they did not make the inquiries about that. So it's an easy challenge to knock out if you're focused on what inquiry is. Now, as Jack has said, the duty arises when there is reason to believe that someone is homeless or threatened with homelessness. And then you can take your inquiries in stages and look at each particular thing. But as the Housing Act 1996 has been amended, and now we have things like the relief duty and personal housing plans, those other duties allow the authority to gather information to enable it to ask questions so that it can answer all of those statutory questions, as well as what duty, if any, is owed to an applicant. So inquiries are going to cover the whole range of things that you need to do under the Housing Act 1996 when someone is, or you have reason to believe that someone is homeless or threatened with homelessness. Jack, can we move on to the next slide, please? Jack's also touched on this point. So initially, the burden is on the local authority. And I say initially because I'm going to highlight a case on review that can be quite important and ties in with the Regulation 7 point that Jack's just gone through. So it's not for an applicant to prove their case. Let's be clear, an applicant can be asked for information, they can be asked to cooperate with the local authority, and they can be asked anything as part of the process that is relevant to the questions that you as the local authority have to answer. But if, for example, the appellant has failed to give you a particular document or failed to give you a piece of information that the local authority thinks is necessary, that on its own, so simply because of that fact, so simply because one document has not been provided that the local authority thinks is necessary, isn't grounds for rejecting the homelessness application. So you need to be very careful. Whilst the applicant can engage, the initial burden rests on the local authority, and it's not for the applicant to prove this case. And this has also become an issue in some of the cases where the contracting out points have been made. So have the local authorities done the right thing in order to allow others to carry out certain duties and functions under the Housing Act 1996. And in absence of a contracting out agreement, the duty to inquire can't be delegated elsewhere either. It rests on you as the local housing authority. Now, that doesn't mean you can't ask others for information in order to discharge your duties. So the most obvious places you may go are your social services department, your education department. You may go for advice to a medical officer of some description, and social services and those types of bodies have duties to cooperate with you in the discharge of your function, but a local housing authority must carry out those inquiries subject to, as I say, a contracting out agreement. Those inquiries, as Jack says, are those that are deemed necessary and can only be challenged on, well, it can really only be challenged on Wednesbury unreasonableness. So it would be an error of law if the local authority has failed to make an inquiry that any other reasonable local authority would have regarded as necessary. So if any other local authority regarded it as unnecessary, you're likely to have erred in law. Inquiries should cover all matters relevant, and we've already touched on the fact that it can be taken in stages. What's important on review, just to contrast all of this in terms of your initial decision making, is that on review, it is incumbent on the applicant to put forward matters that they wish to be taken into account. And this is particularly important. We're reminded to find letter has been served, because there is case law to support that where a minded to find letter has been given and the applicant doesn't come back and challenge anything within there, then there's unlikely to be any argument on appeal that the local authority has failed to carry out necessary further inquiries in respect of that particular matter. So that's why minded to find letters are quite useful in that sense, because it also then gives another hurdle, if you like, for the applicant to come back and actually say, well, look, that matter, you're wrong on that. This is why you're wrong. And this is the inquiry you should take in relation to that. And if they don't do that, then you've got a defence on appeal should they attempt to then challenge that matter, which they failed to challenge at the review stage. We go to the next slide, please, Jack. There's also some other things you have to take into account in relation to section 184 inquiries, but also in relation to any inquiries under review, and as again as said, especially if it's raised on review in particular. So the first one is that under section 182 of the 1996 Act, local authorities must have regard to the Code of Guidance. Now, there isn't a nice, neat section dealing with inquiries. It is littered throughout the guidance, dependent on what you're considering. So you'll find some information on inquiries in relation to local connection in the local connection section. You'll find some information in relation to inquiries in the threatened or of the threatened or homelessness section. So you need to consider the Code of Guidance for the parts of the Code of Guidance that is relevant to the decisions that you are taking. And as Jack says, there's no time limits attached to any of this, no statutory time limits. And interestingly, the old Code of Guidance did give an indication that it should be 33 working days for you to carry out your inquiries and give your decision. But that has gone in the more recent updated Code of Guidance. So there's no longer a suggested time limit there either. But that's not to say a local authority should sit on applications for months, but it might be that slightly more complicated inquiries need to be made in a particular case that are going to take you longer. I'm going to just park the public sector equality duty because that's going to be dealt with on the next slide. But the other main issue that I see arising in homelessness cases on challenge is the Children Act 2004, and where there are children, there's often a challenge to say the local authority hasn't taken into account the welfare of the children. And what the Children Act 2004 does in section 11 is it requires all local authorities to discharge their functions having regard to the need to promote the welfare of children. It's often referred to as a kind of best interest decision, but that's what it requires. So where there's children, local authorities need to be specifically focused on the impact their decision making will have on them, so that they can resist any challenge that they haven't taken into account the Children Act 2004. So moving on to the other thing that we see quite often in homelessness challenges, and that's the inquiries linked with the PSED. Now, the public sector equality duty is set out in section 149 of the Equality Act 2010, and I'm sure you will all be familiar, but in fixing the scope, form and manner of any inquiries that are undertaken, local authorities need to think about their obligations under the Equality Act 2010. And I've included a case there from 2022, the Biding case. And that was quite an interesting case. It was focused on the protected characteristics of disability and gender reassignment. And what essentially was trying to be argued is there is almost a heightened duty when it comes to inquiries if there is a protected characteristic in play. And the court considered an argument that there had been a failure on behalf of the reviewing officer to expand the scope of her inquiries, which meant there had been then a failure to have due regard to, in particular, the protected characteristic of gender reassignment. It was in the context of a suitability challenge. And what had happened is the officer had, the decision maker had approached a PCSO in relation to information about hate crime and gender reassignment in the particular area where the property was situated. And the argument was that she should have asked an LGBT liaison officer instead of a PCSO, because the liaison officer would be much better placed to be able to tell the authority whether or not there had been hate crimes and whether or not areas were suitable for the applicant. And the court actually regarded that as absurd to suggest, and the court decided that whether we were talking about gender reassignment on its own as a protected characteristic, or whether we were talking about disability and gender reassignment together, and that's at paragraph 51 of the judgment. And in light of that, there was held to be no heightened duty in relation to inquiries, simply because the PSED may also be in play. So it was quite an interesting case and can be quite helpful. And I've actually come across county court cases where people are still trying to run the heightened duty, even in light of Biden. And obviously, those challenges have, well, I think so far, in terms of the ones I've done anyway, have been unsuccessful or haven't been pursued at final appeal, because Biden at the moment provides an answer to that. On the next slide, we see other things that need to be thought about when carrying out inquiries and investigations, whether that's in relation to Section 184 or you're at the Section 202 stage. And of course, it goes without saying the local authority should seek information from the applicant, but they should also be giving the applicant an opportunity to fully explain their circumstances. Whether or not that requires an interview, which is one way of allowing an applicant to put their case across to a local authority, is a matter for the local authority. I'm not sitting here suggesting you should interview in each and every case. But if you're considering when to consider an interview or putting questions very carefully in correspondence, my view is it's probably going to be more likely you're going to want to interview or put very specific questions in correspondence if there's going to be certain facts that you as a local authority are going to find go against the applicant, and also where the applicant's credibility is in question. And there is actually some, I think it's a county court case that actually talks about where credibility is in question, then the local authority should have given the applicant an opportunity to come to an interview and give their side of the story before that decision is made. So where a local authority is going to find against the applicant's version of events, you need to think very carefully about the nature of your inquiries and how you put those to the applicants. Any inquiries must be caring and sympathetic. You will also need to think about, if there's interviews, whether or not English is a first language. Do you need to provide an interpreter? Because all of these things could potentially play into a challenge down the line, whether you've done it on Section 184 or Section 202 decisions. Because of course, people can appeal Section 184 decisions if a 202 decision isn't made in the requisite time frame. And I think now I'm handing over to Jack.
You are, but I'm keeping an eye on the clock. And given we've only got 15 minutes to go, what I'm going to suggest we do is we just park these. What we've provided here is some examples of successful and unsuccessful challenges to inquiries and to the local housing authority's duty to make inquiries. And so you'll see that there's some very specific circumstances where particular scenarios have led to a successful challenge. But it's also worth noting that generally an authority won't be criticised for failing to make inquiries of someone they have no reason to believe would provide relevant information. So, for example, in a case where health or education did not appear to be a relevant issue, and no experienced advisor had raised the point, then it would follow that usually a doctor or a school wouldn't necessarily have been expected to be approached in order for a decision to be lawful. But there's some examples there. I just don't think we want to spend too much time on them given the clock.
No, so this then comes back to me. So what do you do once you've finished your inquiries? You have to notify the applicant of their decision. You either have to do that under section 1843 or you do it under section 203 if you're at the review stage. And you should notify the person, you should be given reasons, and it should also be in writing. And that is covered in both sections 184 and section 203. The next slide simply sets out a list of the different types of decisions you're likely to be notifying, and I'm going to allow people to read that list at their leisure. But we've already said there's a number of decisions you'll be making, or you could be making. On the next slide, there's a few examples of recent cases about decisions on what duty, if any, is owed. The bottom two there on intentional homelessness were about hostels and halfway homes. So if you have a case that concerns hostels and halfway homes, you should go and have a look at those two cases, which would be quite helpful to you. The eligibility cases at the top concern the effect of the withdrawal agreement. The C and the high neck cases are actually two conflicting decisions, and you have FETA there. And there's an appeal outstanding on that. It's a bit complicated to go through all the EU law during this webinar, but if you have any decisions that mean that you're considering the withdrawal agreement and the effect of that, you should have a look at those cases. The county court case, I should say, is available on Nearly Legal. I think that's potentially the only place it's available on. So when you're notifying of a decision, going to the next slide, Jack, please. You'll know it needs to be in writing. You have to give reasons. They have to be explained clearly. Any court will, however, read the decision as a whole. So on any appeal, a lot of people can nitpick, and we all know about the case of Holmes Morehouse, and you'll see a lot of nitpicking, just picking out bits that you haven't thought about this, you haven't thought about that. But what the court will be looking at is your decision as a whole and seeing whether or not it can uphold your decision because it's given sufficient reasons. On review, the only thing I stress is that the decisions really do need to be careful to consider everything, address all the issues that have been raised by the applicant, because as we've already set out, there's a bit of a switch on review that the applicant needs to put in front of the local authority what it is saying and what it would like taking into account on review. And then the local authority need to be really careful to address everything that is within there if it wants to stand by the reasons it's given and be able to highlight to the court that looking at its decision as a whole, it has covered all the issues that it's been asked to cover. Jack, I think I'm handing over to you again.
You are, and I'll just take myself off mute. So now I'm just going to look at some common issues which arise in the context of inquiries and decision making. Sarah's covered some of the points already, but I think it's worth just thinking about some specific issues which come up at time and again. And so there's one point that I want to turn to first, and that's in relation to abuse and domestic abuse. There's specific provision in the English Code of Guidance about how to approach issues which arise in relation to inquiries where domestic abuse might be a potential issue or abuse might be a potential issue. One thing that's clear is that it's not appropriate to approach the perpetrator. That might, or the alleged perpetrator. That might sound obvious, but that can obviously be quite a serious safeguarding issue. Obviously, a lot of the time, information will be sought from the applicant and from a variety of different agencies, such as adult care, children's services, health professionals, multi-agency risk assessment conferences, the police, and so on, with the applicant's consent. But it's also worth bearing in mind that when local housing authorities are making inquiries, an applicant might be in considerable distress. And so it's important to ensure that interviewers are trained, that the option is offered for an interview to be carried out by someone of the same sex. It's also worth decision makers noting that corroboration might not be available. And it's important to ensure that there's no blanket approach taken to require corroboration or police evidence in a particular case, and there's a Court of Appeal judgment on that called Bond and Leicester. It's obviously important that the decision maker must investigate accounts of violence when making inquiries into whether accommodation is or was reasonable for the applicant to occupy. And in particular, if the decision maker is considering disbelieving the applicant, it's important that contradictions or inconsistencies are put to the applicant. And so, for example, if you think that their case doesn't add up or their version of events doesn't add up, it's worth putting those to them. That's important. It's another indication, as we saw with Reg 7 earlier, of the need for quite careful procedurally. It's careful to deal with these procedurally in a watertight manner to avoid a potential further challenge. There's some other issues which we cover. I'm not going to go through each and every one of them with one eye on the clock, but in relation to affordability, the leading case on that remains Samuels and Birmingham from 2019 in the Supreme Court. In relation to Section 21, which we've put there, obviously, that's still not been abolished in England, but for local housing authorities in England, when a tenant is served with a valid Section 21 notice, which will expire within 56 days, he or she is deemed threatened with homelessness. And so where a tenant approaches the local housing authority with such a notice and seeks accommodation and assistance in obtaining accommodation, it's important for decision makers and housing authorities to realise that an application for homelessness assistance is being made. Sarah's touched on the issue of engaging children already in relation to the Children Act 2004. It's obviously important to have regard to the need to safeguard and promote the best interests of the children as required by those statutory provisions. Lord Carnwath's sole judgment in Samuels, which is referenced above in the context of affordability, was given in the context of an application for homelessness assistance where a child was involved. It's obviously important for the local housing authority to note that it is under a duty to have regard to the need to safeguard and promote the interests of children. Some of these issues are continued and are set out further here. Sarah's already addressed the PSED. I'm not going to go into that any further for now. Those of you, many of you will be familiar with it already, and it comes up time and again in some meritorious grounds and some less meritorious grounds. In relation to medical conditions, obviously the local housing authority needs to make inquiries to establish whether priority need, reasonableness and suitability. In a particular case, they might have to make particular decisions. But in relation to medical conditions, the use of advisors, the decision maker must act fairly in obtaining relevant information and coming to an opinion. If there's a difference of opinion between the local authority's advisor and the medical opinion given from the applicant, for example, the local housing authority should seek explanations for these differences. The role of the medical advisor is to comment on medical evidence to enable the decision maker to understand issues and evaluate for itself the evidence before it as to the applicant's condition. It follows then that it's not the case that the decision maker has to follow the opinion given from a particular medical practitioner, but obviously if you are going to depart from either a medical consensus or an opinion which is contradictory to the view taken by the particular decision maker, that needs to be clearly reasoned, and obviously it could give rise to a potential rationality challenge. In relation to reasons, that case many of you will be familiar with is Geeston Lambeth from the Court of Appeal in 2019. And so moving on to the issue of the practical issue of drafting a decision letter. Now, obviously, in the context of an appeal, a decision letter will often be the thing which is most important for the judge when they're looking at a particular decision letter. So it's important that the decision letter is written clearly and in plain English, containing the necessary legal references, but it needs to comprehensively explain the findings that it's making and outline the evidence that it's considered and how that evidence supports the conclusion that's being drawn. Obviously, it's important to refer to the relevant legislation and case law and to tailor it to an individual. So avoiding a template approach is important. Sometimes, for example, you can see a letter which refers to she instead of a he, or and so on and so forth. And that can be a real telltale that actually this isn't a consideration that's focused on an individual's particular circumstances. It's important to highlight particular evidence which we relied on and why that evidence is either accepted or discounted or informs the conclusion that's being reached, and to address each of the elements of the decision-making process which are required to resolve the issues which are arising in the particular case. As we've touched on, there's a right to review, and on review, again, it's just important to consider the procedural safeguards. But where necessary, when preparing a letter, it's worth seeking legal input potentially if you think that there's potential issues that arise which could cause legal difficulty further down the line. And so here we've just set out some other powers and duties which arise in relation to alongside Section 184. We're not going to cover those in any more detail today. We've addressed most. We've addressed a lot of the legal framework, but we don't want to go through everything because we'll be here until we all have to go home. In terms of once you get to court on appeal, in the context of a 204 appeal, there's several key pointers which are important for decision makers to or for those responding to the appeal to take into account as they prepare to go to court. And so the first thing when an appeal comes in, a lot of the time, is to consider, is the appeal in time? Is it out of time? So there's a statutory provision for appeals to be brought within 21 days. There is an extension made available, and there's been a recent case on extensions of time, which is covered in some later slides. But obviously, just because the extension is made available statutorily, that doesn't mean that there's carte blanche for applicants to delay. And actually, the court takes a relatively strict approach a lot of the time if there's not a good reason for the delay. In terms of what is the nature of the forum in an appeal, obviously there's a case of Begum which describes how although the court, the nature of the court's jurisdiction is essentially appellate, what the court is really doing is judicial review in the county court. And so what the court is doing is scrutinising the legality of the decision made by the original decision maker and considering whether there is a discernible error of law within that decision. One of the differences between a 204 appeal, statutory 204 appeal, and judicial review, which obviously takes place in the High Court, is that there's no permission filter in a 204 appeal context. It's also worth noting that a 204 appeal could potentially be struck out, depending on the contents of the appeal. And so that's another thing worth considering upon receipt of the appeal. More generally, obviously, it's worth assessing the grounds and carrying out an early merits review to assess, do we think there's much in what's being raised on appeal here? Are there things that we could do which could resolve the issue with the implication of avoiding further litigation that might cost a lot of money? Also, is there any clarification required in terms of what's being argued? Do you understand the grounds? Do they make sense, or do they need amendment? What the court will next want to do is think about directions for disclosure, for sequential skeletons, which obviously are important in setting out the key arguments for each side. There's sometimes provision for witness statements, although there's a case of Ermakov, which obviously says that ultimately decision makers shouldn't, the party shouldn't be relying on witness evidence which is relating to issues which arise after the original decision was made in itself, or what was before the decision maker at the time, and also timing and listings. But in terms of the most important thing to do with dealing with the appeal, it's probably worth thinking, are there good prospects of this appeal being defended at an early stage? And secondly, also preparing a strong skeleton argument which effectively sets out the reasons why the appeal should be rejected if that's the position that's being taken. And so we're coming up to our 45 minutes. Sarah, I think you were going to discuss some recent case law, but I'm not sure how much time we have to do that.
Sorry, yes, I am. I'm frantically also trying to answer all the questions we have in the question and answer. I haven't got around to all of them yet. There was just one question about domestic abuse, and I was trying to find the actual code of the actual paragraphs in the Code of Guidance, but have a look at chapter 21, whoever asked that question, of the Code of Guidance, and also the specific domestic abuse Code of Guidance, because that gives really clear guidance of how you should be dealing with people who have been the subject of domestic abuse, and what inquiries may or may not be necessary dependent on the circumstances and the nature of the abuse and the relationships between the people. So do have a look at that. It's very informative, and it can be something that I think local authorities need to pay a little bit more attention to when they're dealing with domestic abuse. Just having a quick look, there are a lot of recent cases set out there, and you can all go and have a look at them. I know Cornerstone Barristers have quite a few notes on some of them, as well as other resources like Nearly Legal. You'll find most of them on there. I just want to, without running too much over time, I just want to highlight a couple given what we've been talking about today. And the first is on the substantive side. It's the fourth one down, the Haringey case. And essentially this comes back to what officers need to consider on review. And the argument was, as I understand it, that whilst there was a review of suitability, the reviewing officer should have also covered what other duties would be owed, regardless of whether or not the property that was offered was held to be suitable or not. And the Court of Appeal said, no, that's not right. So it comes back to this idea that it's what's raised on review, which is what you really have to grapple with on your review, as opposed to looking at everything again. So what the court held was a request for a review on suitability doesn't amount to a request for a review on every aspect of the local authority's relationship with the applicant. So you didn't need to rethink the entire process, and you didn't need to look at anything that you weren't asked to look at. So that's quite a helpful decision, which I just flagged there. In terms of what we've been speaking about today, especially because getting things wrong procedurally can often be easy challenges to make, rather than saying there's been a more substantive error, is all the ones that are on the procedural sides of there. And I do I do say to everyone attending today, you should go and have a look at them. But the Idara case there, that deals with extensions of time when appeals are brought late again. And it just reiterated, it doesn't set out anything particularly new, but it just reiterated that under section 204 2AB, what had to be shown was both a good reason for not filing the appeal within 21 days, but also a good reason for the whole period as to why the application for an extension of time, for permission to put your appellant's notice out of time, was also delayed. So you need a good reason for both of those aspects. The other one that's probably quite interesting, because I think we're seeing a lot more Equality Act challenges now when it comes to homelessness decisions, and they've been ramping up over the last few years, is the RZH case. And that was a legal challenge to the 202 review decision, but also a claim for discrimination of other aspects of the Equality Act under section 114 of the Equality Act, which allows you to bring claims. And this was a judicial review under the Equality Act and a challenge on a 204 appeal. And what the court said that actually is those can be listed in the county court as a dual listing. So the county court should be considering any claim under section 114 of the Equality Act alongside any section 204 appeal, because it's better case management, it's more proportionate, and all of those things that the courts like to reiterate when it's dealing with matters. So that's the way to promote the overriding objective, is what the High Court said in that case. And finally, the Ivory case. Now, I've advised on quite a few of these over the last few years, and it's really tricky, but it's those cases where you've made your decision, you've made your 184 decision, you've given a review decision. Applicants have often even gone off to the county court, and their appeal has been dismissed. And so you think, well, that's it then. And then a month later, the applicant comes back to you and says, I'm making another homelessness application. And there was some previous cases on this. There was the Harrow ex parte Fahia case and the Erika Begum case and Tower Hamlets case. And those were both considered along with other cases in Ivory. And essentially, the facts in Ivory were sort of unusual because there was also an abuse argument being run, which was unsuccessful. So what had happened is the local authority had gone through everything, and in August 2023, I think it was, the homelessness appeal was dealt with by the county court, and the county court dismissed it. In the April of 2023, so a good few months before the homelessness appeal, the applicant's lawyers had got a medical report under its legal aid certificate for the appeal, but had not disclosed that at any point in time to the local authority and had not used it as part of the appeal. And when the applicant reapproached, she reapproached with the medical report that had obviously been available prior to the appeal being dismissed in the county court. And the Court of Appeal held that her fresh application was supported by new facts, and that new fact was that medical report, and it was not an abusive process, and therefore an application should have been taken. And unfortunately, I think the lesson to be learned from that decision, although go ahead and read it, is although there may still be circumstances where a local authority can say, I'm not taking an application because it's so fanciful and there's nothing new in there, the safest way of dealing with these things is to accept a new application, unless you're absolutely sure you can positively say that there's nothing, that it is absolutely identical to the case that went before. I think that's probably the safest thing for local authorities to do. So I just highlight those few cases. And that ends the webinar today. I do apologise that we have run over. There seems to be quite a few questions outstanding. Just trying to deal with those quickly. Alex, yes, the slides and recording will be sent. I said that earlier. I think it's going to be sent after the hearing today. There's a few other questions. There's another question about domestic abuse. I just say go and read the guidance. A verbal statement can be enough. You have to try and investigate it as best you can. People don't have to report domestic abuse to be the subject of domestic abuse. You have to look at those cases very, very carefully, look at what's happened, and you're just going back to whether or not you accept the case that has been put forward by the applicant. I think we might have to consider some of the others. We will try and answer them. I think we can answer them after this webinar, so we will try and do that for you. I think I've answered about 7 during the webinar as well. So thank you all for coming.